And that flaw is that the words must and voluntarily are used in the same sentence. So I think the exact wording of that section, if I can refer to page 2 of my submission, in the past, under 2007 Employment Relations Act, which was a promulgation at the time that when I was the director of the Human Rights Commission, I worked with the Law Reform Commission at that time to ensure the previous Employment Relations promulgation, and now Act, of course, would comply with all international law. And I noticed, Mr. Chairman, that you had said that you wanted to ensure, or the government wanted to ensure anyway, that this particular proposed legislation was going to comply with international law. Well, let me tell you that it doesn't. And I'll explain to you exactly in which provisions it does not. That's not to say that it can't. I think you need to go back to ERA 2007, particularly the promulgation, because when the promulgation moved from a promulgation, because of 2007, and I will not dwell on those events then, to an act, then things got missing in there. Plus new decrees came into force as well. They were decrees that have to be questioned again. Nevertheless, the phrase that our team takes objection to is subsection 5 and section 6. A worker is not obliged to join a trade union in the ERA before, and now there is a new subsection introduced. A worker must voluntarily join a trade union and engage in collective bargaining. Now, anybody with basic understanding of English language would see that must and voluntarily are internally contradictory. We call it oxymoron in the English language, actually. It's an oxymoronic piece of legislation. And just one phrase, and it just destroys the intention of the entire bill, of the entire piece of legislation that's being proposed. Because we haven't decided yet, and government has to tell us this, we must disclose whether you want trade unionism to be compulsory in Fiji or voluntary. You can't have both in the same sentence, because this will cause chaos and conflict and endless problems for the law-abiding citizens of Fiji, and workers as well, and employers too, the industry, because they won't know. Like if somebody wants to join a trade union and the employer says, no, but you can't because, it says you must be voluntary and we're giving you all of these things, you can't join the trade union, or the trade union says you must join the trade union. How long is this conflict not going to last, and why will it not end up in the courts forever being litigated? Please, that one little section that might look meaningless to most people is in fact the most dangerous aspect of this proposed bill. The rest of the problems in the bill are as a consequence of this section 6 of section 5. And I will now point out to you what the other problems are. If you got that right, then some of the other problems will not occur at all. So why buy on problems? I just think it's important for us all to think about harmonious labor and capital relations, not that people who are at loggerheads with each other forever. We've had this problem in the past in Fiji, where the workers are going off on a frolic of their own. The employers are saying, oh, but if you don't control labor, then we're not going to be able to make enough profit for growth of the economy and so on. But that's not how it is anymore. This is the 21st century, and we should look at a joint enterprise between labor and capital, because if you don't have that, then there won't be any individual growth, there won't be any individual productivity, you won't have productivity in the companies and in the industry, and therefore you will not have economic growth of the country. This is a very simple thing that we are proposing. So that's the main flaw. The second problem with this legislation, and this comes from the main flaw, is that the labor and management cooperation, or is it consultative and cooperation committee, which was given in the ERA 2007, has disappeared. And that particular, it came up in the legislation itself, it has been removed, but it used to be in Schedule 1 of the original legislation. That particular provision, the LMCC, people might know it, of course somebody will say it never worked, labor and capital got together to do any and management got together to do any consultation, but that's actually not right, because if you gave the opportunity, which the Labor Department had to do, then it would have worked. But anyway, the point is it's still there, and it's the one thing that underpins relationship between workers and industry in good faith. By removing it, you're removing the good faith element of 2007 Employment Relations Act, promulgation and act. One of the things, if you look at the LMCC provisions, particularly Rule 8, not only does it work through management and workers having a good relationship and conversation with each other about, some of the benefits that could go to the workers, or the workers might suggest some things for the improvement of the industry, and that's really very healthy because the workers have an interest in the success of the industry. No worker wants the industry to fail because they'll be out of a job, so it's motivated by self-interest. But one of the really important things that I've always thought in the past was that it gave an opportunity for the employer to discuss with the employee what benefits that could be derived as a result of a successful business. And one of them was profit sharing. And that's really an important one because internationally, you will find the big companies like Apple and Microsoft and JP Morgan and Chase, which are banks, so they don't produce things, but they produce money, I guess. They share profits, but it's discounted. They sell them to the workers, and it gives the incentive to the workers to ensure that the company survives with their productivity because they themselves benefit from it. And yet it's disappeared in this legislation. So for me, proposed legislation, for me, the two fundamental errors in this, which is why I'm saying you take time over it, the first one, the actual wording, are we going to be compulsorily unionized or do we have a choice? We can't have both. Secondly, the LMCC, which is a fundamental aspect of international labor organization and all international law premises or principles of good faith bargaining, has gone. Bring it back. There's no reason for it to have gone. And I know probably why it's gone, because if you're going to have, this is the sneaky part of it that I don't really like, and that is that if you say unionism is compulsory, then why would you have an LMCC? That's the problem here. Because unionism is compulsory. You are represented by the union. You don't need an LMCC, a consultative approach with your employer, because the union is going to do all of that for you. So that's really, this is not actually about drafting. It's clumsy drafting. I know that. I don't know who drafted it, but there are people in Parliament who draft, experts, independent. You need an independent person like John Wilson used to be before, Mr. Getaki, the judge now. Excellent draftsperson, but he's a judge now. But we don't know. I don't know who drafted it, but it's clumsy drafting at the very least. But it could be worse than that. It could be an intention to do this, to make it all mixed up, so that, people, labor and capital, are constantly fighting with each other. It's just not right for our country, small that there is, that we are. So let me now go on to say that you have to decide as a matter of policy. You parliamentarians, not all are government, I understand that, but certainly I hope that this will be discussed in Parliament, debated in Parliament, as to does Fiji want compulsory unionism, or does it want voluntary unionism? That's the basic philosophy that has to be discussed and decided first. Once you've decided that, then all the other clauses will not be contradictory, and you will be able to sort things out really quickly. But at the moment, it's neither here nor there. So that's the point. The second one, stemming from that, is the LMCC. For voluntary unionism, LMCC is a really good